Okay, welcome back, everyone. I'm Phil Kessler. I'm your host, and today we have someone who is making up 80% of the brain cells in this webcast. This is Natalia Ouellette, Esquire. She is an attorney out of Tampa, Florida, and one of my favorite people in this industry. And so, Natalia, why don't you say hi?
Hello, everybody. As Phil said, my name is Natalia Ouellette, and I'm an attorney in the state of Florida, and I've been doing this for about 11 years.
Well, seriously, thanks for coming on and doing this. We've done quite a few webinars at this point together, and it's just fun. I just like chatting with you. And so this is exciting for me because I do have like a lot of questions. I get a lot of questions from students that while I have a fair amount of experience, there are some questions that I'm just not prepared for, right? Like I'm just not well equipped enough for. And so this is why I think it's great to have you here, is because I can ask these questions and get really specific, and I know you'll have an answer. So we'll start kind of just with basics, who you are, how long you've been practicing. Tell us about LCO law and how that started, because I know you're a partner at LCO. So tell me how long have you been practicing, all that stuff.
Right. So I've been practicing law for about 11 and a half years now. I love it. I've been in the real estate industry the entire time. So I've kind of hopped between either like businesses that own real estate to clients that owned real estate and wanted to protect it as assets. And then I moved into being the in-house counsel for a title company that did closings all throughout the state. I became president of that title company. So I was president of the title company for about 8 years. And through that, you get to see everything and anything that you can think of in terms of like title issues, what is insurable to an underwriter, what isn't insurable to an underwriter. And at the same time, I had a firm with the president of the title company, with another partner, in which we did the litigation to clear up those issues, and also litigation to assist property owners with possession, sometimes litigation regarding probate matters, but anything and everything having to do with real estate, possession, title, all of that. It's been what I love to do, and I'm a complete nerd about it. As of December of 2019, I switched back to just doing title litigation, possession litigation. And so I've been focusing on that. And that is what LCO law is. This is the 10-year anniversary of LCO law. I'm super excited. And so, yeah. And so it's been great. And I absolutely love real estate investors. One of the blessings of the title company in which I worked was that title company was designed for real estate investors. So whether they acquired it at, foreclosures, tax deed sale, or wholesaling, I became very familiar with like what they needed, their types of title, how it made it unique from the typical buyer seller transaction of real estate here in Florida.
Awesome. Yeah. I didn't know you were president of the title company. It's a new piece of info for me. Sorry. It's early here. I'm on the West Coast, so the sun's like right in my eyes. So I do want to bring up this book that I read. So Natalia has a book. It's Tax Deeds: How to Become and Stay Wealthy by Mastering Liens, Possession, and Marketability. And one of the things that I learned from this book that I did not know prior was simply the difference between a warranty deed and a special warranty deed. I didn't know about the 4 covenants, right? I knew that a warranty deed came with certain guarantees. And I never really knew what a special warranty deed was. I always saw it following a certificate of title, but I didn't really know like the difference. And so one of the things that I did learn in this book was the difference between a warranty deed and a special warranty, and a quit claim, and et cetera. And so my question for you is, what is a tax deed in relation to these? Right, I know this is going to be sort of a, it might be sort of a dumb question, but a tax deed is different than a warranty deed or a certificate of title. And can you kind of explain the difference between a tax deed and those other types of deeds?
Absolutely. So, first thing, a tax deed is a deed issued by the state. It is literally, think of it as like brand spanking new title from the state to an individual. And you can think of it as the way that land grants took place in the 19th century, 18th century, when the United States was like first being created. You would have grants from, the governor of Virginia to such and such parties. So it's similar in that regard, in that it's a granting by the state to an individual. And in that case, it has like a lot of superiority to other types of title in the sense that it wipes out certain private interests that existed prior to that tax deed being issued. When you think of the more traditional warranty deeds, special warranty deeds, things like that. So these are transfers that are taking place between parties that are not the state. So warranty deed, like Jimmy Smith to Claudine Garcia. These title transfers are between similarly poised parties that involve guarantees by the seller to protect and defend the title and the chain of title that exists to that buyer. With a tax deed, it kind of wipes the chain of title to the majority of private interest holders. And I say the majority of private interest holders because there are, at least in Florida, certain liens that survive a tax deed. So county governmental liens, state of Florida, for example, certified final judgments recorded by a county for somebody's criminal activities. Those types of liens survive the issuance of a tax deed. And so it's not a perfectly clean, brand spanking new title, but it does have like the ability to say, wipe away that $500,000 mortgage with Bank of America, or, things like that. So it's special in that regard. Warranty deeds versus special warranty deeds is something that you had mentioned, right? So a warranty deed says, I'm going to guarantee to you, buyer, everything that's in the prior chain of title, any challenges that come up going as far back as, the land being created. Whereas special warranty deeds are generally what investors are more accustomed to conveying to end buyers, because they're saying, I will guarantee to you anything having to do with a chain of title in which I was involved. So anything in which during my ownership may have created a lien, an encumbrance, etc. And it's fairly common for those titles, those deeds, special warranty deeds, to be used when you were the buyer via a tax deed, right? So you acquired your deed that way, or when you acquired your deed via a certificate of title, which is what you get at a foreclosure, HOA foreclosure, mortgage foreclosure, county lien foreclosure. They all give certificates of title. So that's kind of the difference. And then a tax deed, of course, actually gets special treatments in other ways. So a tax deed comes with a specific statute of limitations for challenging it under Florida statute. Other types of deeds get different lengths of time. A tax deed gives you specific possessory rights. So it gives you immediate right to possession, no matter who was in the property, whereas other types of title are subject to tenancy protection laws and things like that. That's out of the window with a tax deed. So those are some of the differences.
Yeah, that's really I just find this kind of stuff fascinating. I really do. And so you had brought up a couple things that kind of made me think. So obviously you can't resell a tax deed as a tax deed, right? Because you are not the state, right? So you have, you have to either, you can quit claim that property over to someone else, which is a very basic title transfer. There's no guarantees. It's just, this is my claim on the property and I'm selling it to you. Side note, I did read about, there was a problem in Florida in the 80s when people were quit claiming like other people's properties. They would like sell like, their neighbor's house for, 50 cents on the dollar with a quit claim deed. And they're just like, well, this is giving you my claim to the property, even though I don't have one. And that was sort of a problem.
So that's part of the thing with quit claim deeds. So part of what you're bringing up is that a tax deed is a very specific type of title. So it has limited marketability, right? So a warranty deed is like the top-notch type of marketable deed. And what that means is you're going to be able to sell that property at top dollar. It's immediately insurable. It's, it's the grand opus level of type of title to convey. And so people are going to pay the most money for that, like top market value for the most marketable type of property. But a tax deed is only has limited marketability until you take the steps necessary to make it a fully marketable title that can have a warranty deed name behind it, whether it's a warranty deed or a special warranty deed. They need the same type of process. And that's what's called generally an action to quiet title. Now, there are special circumstances where you might get a unicorn and you can request a quick claim deed from the prior owner. There's nobody else involved in the chain and no other person that can challenge it. And if they sign a quick claim deed over to you, bam, you've converted your tax deed into a warranty type of title, meaning it's insurable and you can get top dollar for it. But it doesn't happen often. A lot of people are kind of frustrated or upset that they didn't have the money to pay those taxes and prevent that sale from taking place. Or if the property was in an estate of sorts, there might be family members that might be upset at each other. And so the willingness to get a quick claim deed in those types of circumstances goes down substantially. So generally, you do have to do the action to quiet title litigation in order to get marketable title. Fully marketable, meaning to get top dollar for the title that you've acquired through the county tax deed auction. Quick claim deeds, and you were talking about something that we call wild deeds in the real estate kind of like attorney world. Wild deeds, that's a thing that still happens. And so in that case, when you're looking at a chain of title and you see some quick claim deeds, like in the history of the parcel you're interested in buying or that you've just acquired, there might be some names there that you're like, wait a second, how did this person convey title to this person when they're not in the back chain? And so a wild deed is just, somebody saying, hey, I quick claim unto you everything that I have on this property. It might be zero, it might be nothing. Right. And so a quick claim deed gets kind of like that bad rep as well as conveying nothing because of those wild deeds.
Interesting. Yeah, I didn't know there was a term for that, wild deeds, and I come across stuff like that all the time when I'm looking through like the clerk records on a property, and I'm just like, how did this, I have those. And so you had brought up action to quiet title, and so or quiet title action, right? And so it's just that one rolls off my tongue a little bit easier. Quiet title action is a necessity to get top dollar for your property. And I think that's a fair statement. And so what are some roadblocks that might come up in that process? And before you answer, we'll talk about in a moment liens that have the ability to survive a tax deed sale. But outside of liens that may possibly survive this sale, what other kind of roadblocks might you come up against in the action to quiet title?
Okay, so first of all, an action to quiet title is litigation. So it involves filing a case in the circuit court. Circuit court's the one that's got the jurisdiction to deal with title matters. So it wouldn't be county court. County court's like where you get like the eviction, small claims, things like that. So it's circuit court, the one right above that. And in that type of litigation, you have to comply with due process procedures. So you have to find those people in the chain that were those prior interested parties, prior owner, prior mortgage, things like that. And they need to be named in the action. And the reason why this action is required is because instead of having a 4-year statute of limitations in which you wait with your tax deed for 4 years before you can do anything with it, including not just selling it, but refinancing it and things like that. What you want to do is shorten that time period, and that's what the action to quiet title does. So it provides notice to those parties that would have had 4 years to challenge your tax deed and gives them formal notice of the proceedings in which you're saying, hey, I got this type of title. This type of title is considered prima facie, which means like from the very beginning, like evidence that I have superior title to you, Mr. Wells Fargo, to you, Mr. Capital One credit card judgment. And this is your opportunity to say, I either paid those taxes and the clerk held this thing in error, or I accept the fact that, I didn't take the steps necessary to protect this from going to tax deed sale. And so that is what the action is. And it requires, finding parties. Companies are generally easy to find unless they were administratively dissolved. But even then, it's not so hard. Individuals are difficult to find. People move fairly often in the United States. It's a huge country. Sometimes they move out of the country. And so often we have to do a search to try to get as much information as possible on like where these prior owners are. It requires skip traces sometimes, and they might be deceased. The company might not have known that they had passed away, and so it just creates these layers of finding the right person to notify to get the proceedings to get going, to get to a final judgment. And so that's generally the biggest longer term part of an action to quiet title, is getting people served. So that they're notice of the proceedings so that we comply with due process requirements, which is a constitutional right. And those are kind of like the steps. If there's somebody that passed away, we might need to appoint an ad litem, which is a third party that does a search to look for the heirs, to get copies of death certificates. And it's often a bit more of a challenging task for us tax deed attorneys, because unlike mortgage foreclosures, where a lender, they have the social security information and date of birth and all of that of their borrowers, so they're easier to find. All we have is the chain of title. And if your prior owner was named Mary Smith, guess how many Mary Smiths there are out there? And so that becomes the challenge, the complexity involved. And each case can be so different because of the prior owners of record. So yeah, those are some of the challenges.
Yeah, and so if you can't track someone down, say, so you can't find any notice of death, maybe this person is still alive. Would you still was it a point ad litem?
So if you have for example, we have to do a reasonably diligent search to kind of get people served. If we find nothing indicating that they're dead, so we have reason to believe that they are alive, they're just not to be found, they just had to go off grid, or maybe they're just renting, and hopping from place to place, which is frequent. Then in that case, what we do is we complete an affidavit of the diligent search, state all the places where we look for this person, the skip trace we did, all those things, so that we can publish a notice of action to get them served constructively. And this is one of the few types of litigation in which you can give constructive notice of the proceedings by publishing in a newspaper. But in order to do that, you have to have attempted many times to get them served, done a skip trace, and all the other layers involved to get to being able to request publication as a way to serve them. And then publication for these cases is 4 consecutive weeks in a county newspaper, and it varies, the cost varies so much. So for example, Hillsborough County, you can find a newspaper to publish your notice of action for $150 for the 4 weeks. In Leon County, you're looking at $750 for 4 weeks. So it varies significantly because sometimes the smaller the county, the less newspapers that are available. And so they have a bit of a monopoly on their market, and they're going to charge what they're going to charge, but it's required. And so those things can also prolong the litigation. I always do like a prelim search in advance of when I give my clients quotes, because I want them to have a better idea of like some of those roadblocks that are encountered along the way, based on just like my brief search of like, is this person easy to find? Maybe there's an address, maybe there's no address, that kind of thing.
Yeah. So that's interesting. I didn't think about that. The the prices varying by county. Again, really, really interesting. One thing that we were going to talk about was probate, right? And so when someone passes away, right, there are it can make things more difficult, right? And you were alluding to this a moment ago. And do you want to expand on that and maybe the
Yeah.
difference between property or an estate that's gone through probate versus one that hasn't?
Sure. So I'll kind of do like a little teaching moment here. So in Florida, in order for property to transfer from a person who's passed away into their heirs or beneficiaries under a will, you have to probate the property. That means you have to do an administrative litigation case in which the court decides these are the heirs or these are the beneficiaries under the will, and they're now entitled to ownership in these portions, right? And those orders that come out of it are the effective title transfers that put the heirs or beneficiaries as the new owners of that specific piece of property. Sometimes probate doesn't need to happen if, like, the person that died was a co-owner entitled with somebody as a joint tenant with right of survivorship, or they were entitled as husband and wife, then it would automatically transfer to, the surviving spouse or the surviving tenant. But if you're the last one and you're the last to die, then it's going to have to be probated to pass on. And so when you're doing like your searches for a property that you want to bid at a tax deed auction, and you see estate of or estate, that generally means that it has not been probated or it hasn't been completed via a probate. And this makes sense. If people can't afford to pay their property taxes, they normally can't afford to pay the attorneys to do this litigation, because unlike a small claims court or an eviction court in which you as an individual are suing to get your tenants out, etc., if you are an estate, you can't open up an estate case to probate things without an attorney. They are considered a separate legal entity that needs legal representation in the form of an attorney. And so that's difficult for some people to afford. So when you see in the estate of, what you want to check to see is, do the official records have a copy of the death certificate? Is there an obituary that maybe you can find? Sometimes obituaries are brilliant and they're like, such and such, survived by his loving wife, Maria, and their 3 children, and they say who the children are married to. And it just makes it so much easier to know exactly who I would serve in an action to quiet title versus, the obituary of such and such died and this date. And that's it. And you have no other information. And in those cases, it's like, okay, an ad litem's going to be necessary so they can order a death certificate and see who the person reporting the death certificate was and all of that. So there are some cases in which there's been a probate opened right around the time when the tax deed's been issued or the tax deed sale's taking place. And it hasn't been fully probated, meaning there's no order saying these people, have like inherited the rights of this person who passed away, but it gives you information on like who the case, like what's the case number, who's their attorney, their addresses, their names. And so that is also an ideal situation. So either like a really beautiful obituary or like I said, something where the probate litigation has been open, but it just hasn't been completed. And you really can't know until you do a search in the official records and the county court records to see like what level of work has been done to represent the heirs, to find out who they are, all of that.
Yeah. Wow. So I want to sort of shift gears and talk about liens that would or have the potential anyway to survive a tax deed sale. And I was curious your take on this. So I have this opinion that the smaller the form of government, typically the more power that they have, right? And not in the typical sense of power and like, Rome, but like against like say a title, right? So like a city government, then a county, then a state, then a federal, right? And so I have this opinion, and I even thought about throwing HOA in there at one point, but
which is a fair point.
yeah. Is there any merit to that?
Yes. Yes. I find that when it comes to negotiation of liens, the smaller the city, the more tight knit and tiny the community is, sometimes the harder it is to get them to negotiate on lien reductions, on just satisfaction of those type of things. And generally, the greater the political entities, so county, et cetera, the easier it is for them to negotiate. Now, this doesn't apply all the way across. There are some counties that are just absurd in their refusal to negotiate. But for the most part, if you see city of, et cetera, it might be a bit tougher to negotiate on a lien versus county of, or state of Florida, that kind of thing. And then, of course, it depends on the type of lien too. If it's something that's like for a hard cost, like a utility lien, they're going to be very firm about that versus, like there's some overgrowth or there's like some residue that's been dumped on the area. And generally, if you clean that up and, have somebody come inspect, they're much more willing to negotiate. But that's one of the keys too. You've got to clean up any open violations before you go and try to negotiate something with them.
Sure. And I get this question a lot, and I know the answer, but I'll throw it out there because it may be raised. So some of these code enforcement liens you can see be like huge, right? These unbelievable $40,000, $50,000, $60,000 liens that, and this was something he told me that there is precedent that it was actually ruled a violation of the Eighth Amendment, right?
Yes.
And so I get the question pretty often where people will ask me, is there any way that you can reach out to this government entity prior to the sale to try and see if you have the ability to negotiate? Now, I always give the same answer, but I'd like your take on this.
So my answer on that is, if you are going to do this as your business, investing in real estate and all that, you need to develop the relationships with the people at the county level, at the city level, et cetera, of where you are investing. You need to take the time to go talk to them, even like with our pandemic era, with your mask on, et cetera. You go introduce yourself, go say, hey, like, what's the procedure here? Who would I talk to ask about this type of lien payoff? Or, do you guys have an in-house attorney that maybe gives some guidance or feedback, something like that? You need to develop those relationships first so that the door to negotiation is already a little bit open for you when you go into these things. As far as, can you do it beforehand? Well, I mean, generally they can say no if you're not a property owner. Mm-hmm. But if you go in with the right message, like, hey, I'm like seriously interested in purchasing this property at such and such thing. I want to make sure that like it's clean, ready to go, that like all of the adjacent properties go back up in terms of their valuation of the assessment, because now the area is like no longer a blight. And I know that this properties or parcel's been, depressing property values for a number of years. I want to take care of this. You might get somebody a little bit more open to letting you know, okay, here's like our procedure for negotiation. Here's how we normally do it. Here's how long it takes to negotiate with us, that kind of thing. So relationships and communication of why you'd be a valuable person for the county or city is key.
That's a really good answer, and it's a much better answer than I did, which is no. I just I'll just say, if you don't possess that property, it's probably pretty hard to negotiate liens that you may potentially, So but that's a much better answer, right? So if you build relationships, it can open doors.
You build relationships. Now you're not going to be able to complete the form to negotiate a lien down, obviously, until you are the title holder, because you have to have the ability, the standing, as it's called legally, to request that kind of reduction. But if you have created that relationship, et cetera, then the person that gets the form and sees your name, they're going to be like, oh, I know such and such. They're here all the time. They, they talk about how they fixed up this one and fixed up that other one. And, they generally do a good job taking care of this for the county. Or if they're brand new, like they've introduced themselves, like you've come into their system already with a positive opinion of yourself in their mind, which is key.
Yeah, that's good. So liens that can survive, and the list is a fairly small one when we talk in terms of just liens in general, because there's millions of types of liens, but we are essentially dealing with government liens, right? And the biggest offenders that I see in my work, I'd say code enforcement's probably number one.
Yeah.
A tax deed or a tax defaulted property, I think it's safe to assume that it was either, that it doesn't have a mortgage. Most people's taxes are paid through an escrow account. So we can say that this property doesn't have a mortgage. We could make one of two assumptions. Either it was a cash purchase or someone's lived there for a long time and paid off the mortgage. And I find that it's usually the latter. And in that case, I'll say, okay, well, if someone's lived here for 40 or 50 years, and then maybe passed away, then this property might be in a state of neglect, right? So I think we'll see, I see a lot of code enforcement violations. I think that tends to be the main reason. But outside of code enforcement, I'll see sometimes probably the most difficult one for me to figure out what to do with would be child support arrears, because I can't find, it's not public record to see, or at least it's not, I can't find it in the clerk anyway, to find out how much is owed for child support arrears.
Yeah, and those are usually difficult cases too, because family law proceedings are generally closed off to the public. And so it's not it's not an ideal one. If you see one, it's going to be a challenge. And it's also how it's recorded, like who the parties are, because there might be a private litigation case between, father A and mother B. And mother B has a judgment against her for such and such amount for child support issues, but that's actually seen as a private proceeding. Whereas if it's the state of Florida on behalf of parent A against parent B, then that becomes like, again, a governmental lien, because they're the agency that's charged with collecting. And if the lien is one that is collected through the county, so the clerk of, let's say, Osceola County clerk, and they're the ones that are collecting those child support arrearages, right? Then that tells you this is a county lien and this is going to survive. So there are ways to request payoffs for those liens. It generally requires contacting the family clerk to get the information from them. You give them the case number for that proceeding, and they, once you're a title holder, this one you can't really request prior to, because you don't get to build that kind of a relationship.
Sure.
So you got to wait till you're a title holder, and that of course is the challenge. You're like, oh man, how bad was this, right?
I don't think you want to build that type of relationship.
Yeah.
If we know you, it's probably not because you're an investor.
Exactly. So, but then you request it through their system, and theirs usually takes a bit longer to get back to you. Whenever a judgment is held and processed through the county clerk, right, for a family law proceeding, for a criminal proceeding, etc., they take a long time, much longer than a county for their code lien violations and things like that to give you a payoff statement. It's just, they're swamped. Each judge carries between 5,000 and 15,000 cases a year. And so imagine the clerk having to process for the various judges or the various levels. And so it is a bit slow. And then they have a lot of levels of bureaucracy. So like the clerk has to take that request and send it to their accounting department, who has to have like their manager approve it and all that, and then finally come back down to you. So it does take time, but generally, if you see state of Florida, you can consider it to be a surviving lien because it's collected through the clerks at the county level.
So, so another big one that I'll come across is the IRS. And so when we're dealing with the IRS, it is the federal government. And, I think there's a lot of misinformation out there just in general about tax deeds and real estate. You can find an article supporting any viewpoint that you want, right? And so it's really difficult to get the answers on certain questions. And let's start with an IRS lien and how to approach that and what the possibility of getting that taken off the title is. I know there is a statute of limitations on those, right?
So there's kind of what's called a redemption period, and there's also a period of time in which that lien is a valid lien that can attach to property by Florida statute. And that's because the IRS has decided, okay, I'll make my lien survive as long as the state statute says I get to survive.
Okay.
So IRS liens, of course, are liens that are put on because people or companies did not pay what they were supposed to pay the Internal Revenue after having done an audit and deciding you owe way more in taxes than you paid. And so when a lien like that gets recorded, it has 10 years from the date of recording to attach to property. So any property that's acquired by that person who's, the person named in the lien, for the next 10 years, it's going to attach. And they get a period to a renewal period that is stated in that very lien that says if you re-record by this time, you get another 10 years on top of that. So it could be up to about 20 years or so that this lien can attach to the property of the delinquent taxpayer. In those cases, if there's a tax deed auction that's going to come up, the clerk has the duty, the obligation, if this lien is still valid, meaning it hasn't expired, right, based on the recording period. Because if it's expired, you don't need to worry about it. But if it hasn't expired, then the clerk has the duty to notify the IRS that there's a sale taking place for foreclosure of non-payment of taxes. And that way the IRS receives notice and they have the opportunity to redeem the property. So this is something that the federal government has kind of decided to put themselves in an inferior position, because normally an IRS lien is superior to everything. Normally an IRS lien, even if it's just against you, it can attach to the spouse, to your spouse's property too, if you guys own it jointly. So that's something very important. Normally IRS lien's super strong, but they decided under federal law that it's so important for states to be able to collect taxes and bring in tax revenue, that they're made themselves inferior with a right of redemption period. What's redemption means? It means the IRS can say, okay, that property sold for $6,000, but the value of that property is so enormous, it's got so much equity that it could satisfy my lien. So I'd rather to redeem it for, the redemption amount that's listed per the IRS, 6% plus what you paid, within 120 days of the sale fee. So there's that 120-day sale period that applies, redemption period that applies when there's an IRS lien in place, which is what I recommend to, if you are an investor and you want to start your flip, et cetera, on this property that you acquired via tax deed and there's an IRS lien on it, either fill out the form to request a release of that lien to the IRS and wait for them to return it to you, and then there's no IRS lien redemption, and then start working on the property, or wait the 120 days and then start working on the property, or have the IRS be named in your action to quiet title, and they generally file a disclaimer of interest within 30 to 45 days of being served. So there's ways to shorten that 120-day period, but you definitely should not be doing anything to flip it, repair it, etc., until you've taken the steps to have that IRS lien be gone, because you're taking a huge risk that they redeem the property, and more so if it doesn't have a mortgage on it.
And I know what property you're talking about. Was there an IRS lien on that property?
No, I'm not talking about any specific one.
Okay.
Like this
All
is
right.
this is in general. Like this happens often. I have to remind my investor clients, hey, if you've got an IRS lien, have you taken the steps necessary to shorten your redemption period, or have you waited the redemption period before starting construction? This is actually a fairly frequent bad habit of investors, is that they get into something and they're like super excited and they start working on it and they forget about the IRS redemption period.
Good to know. Okay. So the IRS actually puts themselves in an inferior position to have the right to redeem, and basically they're paying any real estate investor, I believe right. So 6%, and they say, I think I read it actually in your book, if I'm not mistaken, but they're paying. They know real estate investors are putting their time and money into this, and that is just like what they've deemed like an appropriate reward for their time.
Yeah, there's certain money that they are willing to reimburse for improvements, but you've got to be extremely diligent about that. So if you mess up, if you're like, oh my God, I put a roof on this thing, then you better have a paper trail to prove absolutely all of that as part of what the IRS might reimburse you, but they definitely have to reimburse you the purchase price and 6% interest rate per year on that if they're going to exercise that right of redemption. Just be aware that they might not reimburse you for the improvements.
Interestingly enough, that is also how it works in redemptive deed states like Texas. You do have to keep a very good trail of itemized receipts, but they will pay you back for anything to bring the property up to code, but not, that's like what you would call a flip, right, or a rehab, like nothing that,
right.
just to bring it up to code, they'll pay you back for that. Fannie Mae, Freddie, this is a question I've gotten recently, and I'm not 100% sure. And I think I know the answer, but I don't want to tell anyone anyway. So this is actually on the request of, it's on the request of me, I guess. But it's because somebody else had asked me this. So Fannie Mae and Freddie Mac, and so any sort of like HUD, like mortgage, would these be considered government liens?
No.
Okay. Okay.
So
yeah, go ahead.
Here's why. Okay. So there is a difference between, for example, an SBA mortgage, which literally says Small Business Administration loan, da da da. The lender is a Small Business Administration, et cetera. And then they have special like priority position, when it comes to like their lien holder position. But Fannie Mae, Freddie Mac, FHA, VA, USDA, those are all insurance programs. Think of them as insurance programs to encourage lenders, private lenders, to loan out money. So they are not the lien holders of record. They are the insurance company for the lien holder of record. And as such, it doesn't render it a government priority lien. Okay.
Yeah, no, that makes perfect sense.
Yes.
I did find an SBA lien. So there's an SBA loan lien on a property in Jacksonville that might have been a $50,000 property, but it was for about $700,000. Thought that was a good one to turn down. So let me ask you, Natalia. So we have seen, obviously recently with with the pandemic, we've seen a lot of SBA loans going out to individuals, just essentially taking free money from the government. Those PPP loans are essentially SBA loans. Is that correct?
So the PPP loans are SBA backed loans. Think of it as like the Small Business Administration being the agency who's kind of like insuring these loans and the payback for these loans when it comes to the PPP ones. Mostly it's businesses, although there are people that are self-employed and they're also entitled to get the PPP loans if they qualify. But these loans are not guaranteed, meaning they are not requiring collateral in the form of liens over real estate at this time. So the program has created these loans, but they're unsecured loans. So I wouldn't say that they would attach to any particular piece of property because they're unsecured. And until they were reduced to a judgment, then at that point, if they're reduced to a judgment, recorded, certified copy of that final judgment in the official records of the county where that person has real estate, they don't become liens.
So let's keep going on that thought there. So the until they become a judgment, right? And is that like could you kind of say that for federal liens in general? Federal liens are it seems like they might be hit and miss on whether they survive, but I think it might be that term lien that.
So lien is different from judgment. A judgment says, this party won against this party this much money, right? And a court said, you're owed that much money from party A. That is not reduced to a judgment that is a lien in the state of Florida until a certified copy of it is recorded. But that's different from things that are just flat out liens, like that don't require a judgment. So for example, an IRS lien literally is called an IRS lien. You're not going to see something calling it a judgment. You're not going to see an order coming in from a court kind of a thing. You're not going to see a certified copy of it. It's still a lien on property. Counties tend to have that too. Sometimes you'll see like an order of a process where there's findings about the overgrowth violation, et cetera. And that order isn't necessarily a lien until it gets a certified copy of the judgment becoming, like it says now certified copy of this, da 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 da. And when you see certified copy of, that they've reduced it in essence to a lien on all of the real estate of that particular property. Other types of county or governmental liens are just like, they're just literally say lien of blah, blah, blah. And so they're attaching to that particular piece of property. But if you see a certified copy of a judgment of a county ordinance violation lien, then it attaches to all of the property that person had. And people sometimes have more than one piece of property. So it's also key that if you're looking at tax deed property, don't just look at the things that are based on their legal description. If there's a certified copy of a judgment and it's a county one, it's going to attach.
Yeah.
That's important to know.
Yeah, that's good to know. We had talked a little bit prior to this, and you had brought up the CDC moratorium and that the new legislation. Am I right?
Not new legislation. A federal judge found that CDC moratorium, and this was in the evening of February 25th, they found it to be unconstitutional. And this is something that I've kind of gone over with my investor clients. I talk about it in a couple of other websites where I write blogs. So the CDC is an agency of the executive branch, right? So President of the United States, they have all of these like sub-entities, Department of Energy, HUD, all those things. And the one that relates to health, human services, all that, the CDC is under that. So it's part of the executive branch. And through the prior administration, through the Trump administration and the Biden administration, the CDC had attempted to promulgate a moratorium on eviction proceedings for residential evictions for non-payment of rent. Their argument was, there's a pandemic, we want to reduce the number of people out on the streets, and therefore we're just putting in a moratorium. It required tenants to sign an affidavit swearing and affirming that they've tried all these other methods in order to acquire or secure rent to pay that to the landlords, and that would stay, meaning stop an eviction proceeding or prevent it from being opened. The federal judge in Texas, and it unlike state courts, where if something is decided in that state court for that county, it only applies for that state court in that county, right? When you have a federal proceeding regarding constitutionality, that applies nationwide.
Yeah.
unless there's another similar thing on that same kind of issue that's conflicting, and then you'd need the appellate courts to kind of deal it out and say, okay, no, it's this. But right now, that's the decision. So nationwide, the ruling of this federal court from Thursday said this is unconstitutional. And here's the reason why. Not to be mean or anything like that, but it's just outside of the purview of what the federal government can do. So the federal government has limited authority on what they can legislate on, and that's based on the Constitution of the United States. Congress has congressional authority, right, under Article 1 of the Constitution, and so that limits it. And a lot of the congressional rules, laws, et cetera, come from the Commerce Clause, the ability of Congress to regulate commerce between the states and internationally. So if you're going to do an order, some sort of like executive kind of ruling, all of it needs to go back to some sort of authority that Congress has authorized that agency to do. The CDC has never been given authority to deal with or control property rights, which are something that's not commerce between the states. Property is fixed. It doesn't move. A building doesn't, go from here to Georgia. It just doesn't. It's not part of like the nature of real estate. And so the court found that there's not a sufficient nexus between congressional authority to regulate interstate commerce or international commerce for the CDC to impair activity between landlords and tenants, which is something that's fixed, right, in residences. And therefore, it is not within like the authority of the federal government. It's something that's strictly under the police powers of the relative states. And the states can do it. The states have the authority to say, I'm putting in a moratorium on such and such thing for X period of time. We had that in Florida through September 30th of last year. The governor had issued a moratorium on evictions and foreclosures. Perfectly legal. May not have been liked by people, but the states have the authority to do that. The federal government doesn't. And so that was the finding. And so this CDC moratorium can no longer be used to delay or prevent eviction proceedings from taking place in these residential properties.
You give the best answers to questions. I just want you to know that. This is why I love talking to you. I have two last things. I know we're running short. I wanted to go back to that immediate possession, right? And so, you take immediate possession of the property, and once it's recorded, if I'm not mistaken. So once it's recorded in the clerk's office, you can take immediate possession of the property. What are some worst case scenarios? If there's someone in there, can you just call the sheriff and say, get out? Or do you have to file any sort of
No, you do have to file something if they refuse to leave. So immediate possession is like a legal term. It means that nobody else above you, the tax deed owner, or whoever you granted the tax deed to, let's say you quit claimed it over to another investor who wants to take care of like all the other stuff, right? Make a quick buck that way. That grantee of the tax deed or grantee of a tax deed has the right to immediate possession, meaning nobody else can challenge the possession above you. But if they refuse to leave, you can't do self-help activity, meaning you can't like remove all the doors or, barge in there with like a hose and, push people out. You can't do that.
Right.
Just like you can't do that if your lease with your tenant is over and like they don't have any possessory rights at that point. The lease is expired. They haven't paid rent because there's no new rent agreement. You can't do self-help there either. Those are considered illegal activities. So what immediate possession means is you have the right to file a suit in the court to get a writ of possession, and that suit is treated through summary procedure. Summary procedure means that instead of these people having 20 days to respond to the proceedings, they only have 5. So they have a week to respond, and then generally you get a final judgment entered fairly quickly. So within 3 weeks or so, you can have that person out. And generally, once that person sees that a judgment has been entered against them that says you have the right to possession, instead of waiting for the sheriff to come and forcibly remove them, because then once there's a writ of possession, they get that right, they'll generally take their things and go. But that is what immediate right to possession means. It means it applies again to former tenants of that particular piece of property, to former owners, to heirs of that particular piece of property, whether it's commercial or residential, it doesn't matter.
I do have another question actually, and this is at the request of one of my students. One of them's so it's a two-parter, and one of it's partially me. Have you noticed an uptick in the amount of vacant lots that you have seen coming through in specifically? I've noticed it in Brevard counties, Sarasota counties, and Lee counties. I've been seeing this uptick, this really serious growth in vacant lot sales, and just on whether it be on like the regular like the MLS or through tax deed sales. It's a much more competitive world than it was 6 months ago.
Yes, and there is a specific reason for that. You know how you said 6 months ago? Well, guess what came out 6 months ago? That CDC thing.
Oh, huh.
So right now, or at least up until Thursday of last week, it was incredibly difficult to remove certain tenants from properties to get possession back, whether it was through the traditional eviction proceedings or through, you acquire title through a mortgage foreclosure or an HOA foreclosure. If there were tenants there, you weren't able to flip those properties or sell them or put them on the market because you had people that are just refusing to leave, and you have courts that are unwilling to remove them because there's this federal thing saying you can't because they signed this affidavit. And so it created a lack of properties in the market that have like actual structures on them because of the tenancy thing. And therefore it increased the value and the availability, or the focus, right, on vacant land parcels, because those don't have those issues, right? Vacant land parcel, you're not going to have tenants. And so you can flip and sell without it being affected by the federal laws at issue. And then nationwide, you also see the increase of vacant land thing too, because some states do have moratoriums still in place regarding evictions for residential issues. And so that they're also having a market in which all these residential properties are not available. And so what becomes more prominent is vacant land. And, what's more prominent also starts to become more of like competitive too in that regard, because it's like, if you can own a vacant piece of land, you can flip it that much faster. You can sell it that much faster. And so that is why the CDC moratorium impacts what you're seeing and the increase of vacant land. But I absolutely am seeing an increase in vacant land transactions. Yes.
Yeah, interesting. Action to quiet title on vacant land, necessary?
Yeah, it's still going to require marketability purposes that it be done. To a title insurance underwriter, it's irrelevant that there's a structure there or not. And that's because lot whatever, block whatever is what they're insuring. Right. So to them, it could be a 3-2, it could be a 1-2, it could be nothing. It still needs to have that clearance of the title in the chain taken care of and addressed.
Is it easier to quiet title on, or is it?
It's not necessarily easier. Like, it might be easier in that you don't need a clause to remove somebody that's in unlawful possession. Sometimes people do need to have like the right to possession within the quiet title action done. But it can be just as lengthy as one of the longer quiet title ones, because if that person that owned it prior to is dead, they could have 6 heirs, they could have 20 heirs.
Right.
And so you don't know that until the search is done, and there's some sort of determination as to like how many people are going to have to be served in this to get clear title. And it doesn't matter whether it's vacant or not.
Is there anything else that you want to talk about and that you want to mention, plug before we hop off?
So I just really want to address also a little bit more about like the probate aspect, because it's confusing, right, to investors. Like, okay, do I have to do a probate if I buy a tax deed property. No, you do not have to do a probate for the prior owner in order to do the title clearing aspect of it. But one of the bigger things is appointment of an ad litem. An ad litem, people don't know what that is, what it means. So an ad litem is like a third party that the court would appoint in the quiet title action that does that job of doing the search, of looking for the heirs. And the reason why I couldn't do it as the attorney is because I'm not considered neutral. I'm considered to be the one representing the investor, right? And so to give the authority for me to represent the defendants and their heirs and all of that would be kind of absurd. So an ad litem and the cost of an ad litem is something that people should keep in mind when there's an estate. Think of it between $500 and $800 for an ad litem and all of the things that they do to find the heirs, produce a report, request death certificates, those types of things. So just something to keep in mind when it comes to cost of litigation with quieting your title to a tax deed auction. But it makes sense because you'd rather be able to sell your piece of land for $115,000 versus, only being able to get 20 grand if you convey it via quitclaim deed. So it way more than offsets the cost of doing a quiet title. The profit is far more significant if your title is marketable. Yeah, so.
Okay, so I want to thank Natalia for being on today. I do want to talk her website, lcolawfl.com. You can go there and reach out and contact Natalia for any of your real estate legal needs. Below this video, I think below this video, maybe above it, maybe this way, that way, I don't know, but we're going to put a link to her website and to her YouTube channel, which if you are not subscribed, you should absolutely subscribe to her YouTube channel where she talked about the CDC moratorium the other day. Third, I do want to just say, buy this book. If you found any of this information interesting, go and buy this book. You can buy this book on Amazon. And again, it is Tax Deeds: How to Become and Stay Wealthy by Mastering Liens, Possession, and Marketability. Natalia Ouellette, Esquire, thank you so much for being on. I really appreciate it, and I always enjoy our talks.
Always a pleasure, Phil. Thank you.